me start the seminar with this question. Why would anyone care about non-competition, non-solicitation, and trade secret agreements in the state of Florida? Well, how about what Eric Holder, the former U.S. Attorney General, said? There are only two categories of companies affected by trade secret theft: those who know it and those who haven't been compromised yet. Or what about the New York Times reporting in February of 2018 that Uber and Waymo had settled a trade secret lawsuit for $450 million? Or what about the economy becoming increasingly more virtual and employees from all levels leaving for a competitor? As one commentator has put it, a thumb drive with a half a dozen spreadsheets can leave in a novice sales professional's pocket and seriously damage the former employer's business. That's the reason why everyone in Florida should be concerned about trade secret, non-competition, and non-solicitation agreements. It's because they're enforceable if they're properly drafted, properly executed, and properly enforced. But that point seems to often be lost on both employers and employees. And if you haven't already experienced this, you probably will. This involves the same basic fact pattern, but with two twists. And those twists deal with whether there is or is not a valid non-compete agreement. And then this fact pattern is going to consider both the employer and the employee's perspective. First, the basic fact pattern. A former employee is competing against the former employer company, and he's using the company's secret information. He's doing business with the company's customers. He's hiring away the customers of the current employees of the customer, and he's significantly damaging the company's business. So the first twist is when the employer comes in to try and find the legal remedies that he has available, and it turns out that the employee has no employment agreement, no non-compete agreement, no non-solicitation agreement, no trade secret agreement. And the employer is like, wait a minute, you mean these damn things are enforceable? Same fact pattern, different perspective, and one critically different fact. And that is, there is an enforceable non-compete agreement. And the former employee comes into your office after he's been sued by the former employer. And the employee, remarkably, says something similar. Wait a minute, you mean those damn things are enforceable? And that's really what is going on. Before I started, I didn't go through what the agenda was going to be. It's really quick, and you'll see. But now I'm the viewpoint of the employer, the viewpoint of the employee. Now, before we turn to the actual Florida statute and the common law, let's talk a little bit about the brief history of non-competes. Restrictive covenants and non-competes typically arise in two situations: either employment agreements or the purchase and sale of a legal or equitable interest in a business entity. And the idea has always been to try and prevent somebody from competing by either working for a competitor, working in a line of business, using trade secret information, or trying to solicit employees or customers of the former employer. In a common law, non-competes and restrictive covenants were often found to be invalid and unenforceable. So Florida, like a lot of states, came up with statutory guidelines, and that helps determine whether restrictive covenants are enforceable. And the Florida non-compete statute has been revised many times, with the most recent major rewrite about 25 years ago. Here's the good, the bad, and the ugly of restrictive covenants and non-competes. And that is that, sure, free trade is statutorily protected. That's good. That would help the employee. Valid restraints of trade, though, are allowed if you follow this statute. That's good for the employer. The thing that's good about the courts for the employees and employers is that courts try to balance the interests of the employee and the employer, looks at the facts of each case, looks at the statute and the common law that's been decided on the statute to try and figure out what's fair. A through C on the slide are all good. Here's the bad. Doesn't matter what side you're on, litigation is expensive and the expense is front loaded. And what that means for practical terms, whether you're a lawyer or you're the client, is that if there is litigation, what happens is the plaintiff employer or the seller of the business interest would file a lawsuit and try to seek an injunction. All the discovery, all the effort is at the beginning of the case. And here's the ugly. One side loses. It's inevitable in our system. You have a winner, you have a loser. And the other ugly part of it is if you go there, another person is deciding your destiny. It's going to be a judge, and the judge has control over what's going on. So in Florida, contracts can both restrict and prohibit competition both during and after the term, so long as the restrictive covenant is reasonable in time, area, and line of business. And the starting place of any discussion of restrictive covenants and non-competes always has to be with the statute, and that's found in section 542.335. Please note that this statute only applies prospectively, and that means that it will only apply for actions and non-competes entered into or on or after July 1st of 1996. You might find it interesting, before we get into the actual depth of this statute, to see what another court thought of the Florida statute that we're about to discuss. And this is from New York State's highest court. It refused to enforce Florida's non-compete statute because it found that it was contrary to the public policy of the state of New York. And in the words of the New York Court of Appeals, the statute in Florida failed the, quote, truly obnoxious, end quote, test. So what is a restrictive covenant? And are they enforceable? And when are they enforceable under the statute? Enforceability depends on whether the court finds that the time, area, and line of business restrictions or prohibitions are reasonable. But first, the statute provides that the court shall not enforce a restrictive covenant unless it's in writing, and the writing is signed by the person against whom enforcement is sought. Then the person seeking enforcement of that restrictive covenant is required to plead and to prove the existence of one or more legitimate business interests that justify the restrictive covenant. So what are legitimate business interests? The statute sets forth a non-exhaustive list, and it's important to know that this list of 5 categories is non-exhaustive. It's what you look at, but it's not everything that you would look at. But look at these categories, and I think you get an idea where the legislature is going. The first one is trade secrets, as defined by section 688.002, subsection 4. Now, at the beginning, what I should have done was said that I'm going to do the part of the presentation that deals with non-competition and non-solicitation agreements, and then the presentation is going to be turned over to Teresa Phillips, and she's going to deal with trade secrets, and in particular, that section. And it's the number 1 section in the statute for a reason. It's one of the most important things that an employer or an owner wants to protect against, and that is their confidential and trade secret information. And number 2 in the statute is that valuable confidential business and professional information that otherwise does not rise to the level of statutory protection found in trade secrets. The third category is substantial relationships with either prospective or existing customers, patients, or clients. The fourth category is goodwill, and that's associated with 3 separate factors, and that is a specific geographic location of where the business is, a specific marketing or trade area where the business is, or extraordinary or specialized training that the business provides to the employee. So the key here in drafting or enforcing restrictive covenants is that you have to have a legitimate business interest, because any restrictive covenant that is not supported by a legitimate business interest is unlawful and is void, and that means it's unenforceable as a matter of law. In addition to pleading and proving a legitimate business interest, the person seeking enforcement of a restrictive covenant also must plead and prove that the contractually specified restraint is reasonably necessary to protect the legitimate business interest or interest justifying the restriction. So what are the practice takeaways that you can take here, whether you're a client or you're a lawyer? And the first one is that the core parts of the statute are protection of legitimate business interest, and that's protection from competition. But it has to be reasonably necessary to protect that legitimate business interest. Legitimate business interest, reasonable to protect it. This morning when I was going back through the statute, I saw that the word reasonable or some derivation of reasonable is listed 17 times in the statute. Legitimate business interest or some derivation of that is listed 8 times in the statute. That, I think, really delineates for anybody looking at the statute what are the important parts of it. Now, to continue on with the statute, there is statutory burden shifting, and it's important to note that. Once the person seeking enforcement of the statute establishes a prima facie case that the restraint is reasonably necessary, then the burden shifts, and the person opposing enforcement of the restraint has the burden of establishing that the restraint is overbroad, overlong, or otherwise not reasonably necessary to protect the legitimate business interest or interest. There are statutory modifications that are allowed. The trial court has discretion if it finds that a contractually specified restraint is overbroad, overlong, or otherwise not reasonably necessary to protect the legitimate business interest, to modify that restraint and grant only the relief necessary to protect such interest. And the reason why that's important, whether you're looking at it from a drafting or an enforcing point of view, is how far do you push the line in the documents? And my suggestion would be go ahead and push the line, because the court has the discretion if it finds that there is something that is not enforceable to revise it for the parties for something that is enforceable. Now, you've got to be careful in the drafting process, and you want to make sure that there's language in the agreement that says that the provisions of the contract, each independent clause or provision is independent, not dependent of the other. And that if one of the clauses or provisions is thrown out for being unenforceable for any reason, so all the rest of the agreement survives. So if something is thrown out, the court can rewrite it, the rest of the agreement survives, including what the court has rewritten. The next part of the statute that's important to know about is the rebuttable presumptions. The statute sets forth a bunch of rebuttable presumptions that the trial court is required to apply. And that's really important. The trial court is required to follow the statute, and if these things come up, it's supposed to follow them, and they're important. Please note that these only apply to post-term restrictive covenants that do not involve trade secrets. So what Teresa is going to talk to you about later, this does not apply to. So the rebuttable presumptions involving the enforcement of a restrictive covenant against a former employee, agent, or independent contractor not associated with the sale of all or part of a business interest are that a trial court shall presume reasonable time of any restraint 6 months or less in duration. 6 months or less presumed enforceable. But the trial court shall presume as unreasonable in time any restraint more than 2 years in duration. Now, the rebuttable presumptions involving the enforcement of a restrictive covenant against the former distributor, a dealer, franchisee, or licensee of a trademark or service mark not associated with the sale of the business interests are that the trial court shall presume reasonable any restraint 1 year or less in duration, and shall presume as unreasonable in time any restraint more than 3 years in duration. Moving on to the rebuttable presumptions involving the enforcement of a restrictive covenant against the seller of all or part of the business interest are that the trial court shall presume reasonable in time any restraint 3 years or less in duration. On the other hand, the trial court shall presume as unreasonable in time any restraint more than 7 years in duration. Now, the rebuttable presumptions we've been discussing are only applicable to the enforcement of non-trade secret restrictive covenants. For the enforcement of restrictive covenants predicated upon protection of trade secrets, the rebuttable presumption are that the trial court shall presume reasonable in time any restraint of 5 years or less, and shall presume unreasonable in time any restraint of more than 10 years. Here are some practice takeaways, whether you're a client or a lawyer. The court can rewrite the time limitations, as we've talked about. The presumptions are rebuttable. As I said, why not push the line on presumptive reasonableness when drafting the contracts? When defending enforcement, why not look at whether the contract specifically is overbroad, overlong, or otherwise not reasonably necessary to protect legitimate business interests of the company. Additional statutory guidelines for the court. The statute also provides that written agreements for third-party beneficiaries, assignees, and successors have items that the trial court is required to look at. First, the trial court is required to enforce a restrictive covenant in a written agreement if the person seeking enforcement is a third-party beneficiary of that contract or is an assignee or successor in interest, but only if, in the case of a third-party beneficiary, the restrictive covenant expressly authorizes enforcement by a party's assignee or successor, or in the case of an assignee or successor, the restrictive covenant expressly authorized enforcement by a party's assignee or successor. The takeaways: make sure that when you're drafting, advising, litigating, signing these contracts, that there are provisions expressly authorizing enforcement by the party's successor in interest or assignee. The other statutorily required considerations by the trial court in determining enforceability of a restrictive covenant include defenses, rules of construction and statutory construction, enforcement, injunctions, and attorney's fees. For defenses, the statute requires that the trial court shall not consider any individualized economic or other hardship that might be caused to the person against whom enforcement is sought. The trial court may consider, though, as defense, that the person seeking enforcement no longer continues in business in the area or the line of business that is the subject of the action. Next, the trial court shall consider all other pertinent legal and equitable defenses, and the trial court shall consider the effect of enforcement upon the public health, safety, and welfare. Now, the rules of construction and enforcement are also set forth in the statute. This is beyond whatever you might find in the common law or the cases decided by the appellate courts. The next is trial court shall construe a restrictive covenant in favor of providing a reasonable protection of all legitimate business interests. The court shall not employ any rule of contract construction that requires the court to construe a restrictive covenant narrowly against the restraint or against the drafter of the contract. Next, the trial court shall not refuse enforcement of an otherwise enforceable restrictive covenant on the ground that it violates public policy unless the trial court specifically articulates that public policy and specifically finds that the specific public policy substantially outweigh the needs to protect legitimate business interests established by the person seeking enforcement. The next section of the statute deals with injunctions and again lays out for the court, the parties, and lawyers what's expected. First, the trial court shall enforce a restrictive covenant by any appropriate and effective remedy, which includes a temporary and permanent injunction. The violation of a restrictive covenant, so long as the court finds it's enforceable, creates another presumption, which is of irreparable injury. Next, no temporary injunction shall be entered by the court unless the person seeking the injunction has posted a proper bond. And the court will not allow the waiving of the requirements of an injunction bond pursuant to the statute. Attorney's fees. In the absence of a contractual provision, the statute provides that attorney's fees can still be awarded to the prevailing party in an action seeking enforcement or challenging the enforceability of a restrictive covenant. Finally, there's some additional statutory rules of construction. The trial court shall not construe or interpret the statute to legalize or make enforceable any restraint of trade that's otherwise illegal or unenforceable under the law of the United States or Florida. So for a long time, as I've been talking about the statute, I've had up a slide that talks about whether this is a pro-employer statute. And these are two of the provisions that I talked about, and the reason why I think it's fair to say that it is. It precludes the court from considering any economic or individualized hardship that can be imposed against the person against whom the enforcement is sought. Another example is the trial court is precluded from narrowly construing the restrictive covenant against the restraint or the drafter, which, let's face it, most of the time is the employer or the owner of the business that's being sold. Now, this slide talks about the common law, and here's what I can tell you about that. If you were to go to the Florida Digest and you would click on the statute and you would look at the number of cases that have been reported as decisions revolving that statute, it's almost 500 different decisions since the statute was first enacted. And each of those decisions, I think it's fair to say, turns on a couple of different factors, which makes it difficult to talk about each particular case because each case turns on the facts of that particular case, which includes the witnesses, includes the underlying facts, but also includes the documents. And not every contract follows the statute, and not every contract follows the different precedent that's been set forth by the common law as courts try and interpret the statute. So it's difficult to say one fits all, but some of the cases, I think it's also fair to say, are all over the board. Now, the New York case that we talked about earlier, I'll get to these cases in just a little bit, but the new case, the case that we talked about earlier, the New York case, that was truly obnoxious, that focused on those two parts of the statute, reasonableness and legitimate business interest. And I think it's fair to say that not only is that case focusing on it, but there are other state and federal cases from around the country that look at Florida statutes and sort of say, what the heck is going on down there? And there are several cases that I've been able to find that they're trying to, in other states and sometimes in federal courts within the state of Florida, try to find ways around some of the statutory requirements. You know, in that New York case, they talked about the idea that it was reasonable. It just doesn't make sense when you're not going to consider what the impact is on an employee and what the hardship is going to be. There is a case I want to point out to you. It's called the Transunion Risk and Alternative Data Solution versus Mclennan case. It's from the 11th Circuit in 2015, and it's not a reported case that can be used for precedent. It's not in the supplement or the reporter. It's in the federal appendix, 625 Federal Appendix 403 if you want to take a look. And the issue there was really interesting to me, and it was whether there was a conflict between the Florida non-compete statute, which precludes the consideration of the hardship, as we were just talking about, and Rule 65 of the Federal Rules of Civil Procedure. And as you're probably aware, in that rule, the party seeking injunctive relief is required to establish that the threatened injury to the movement outweighs whatever the damage is to the proposed that the proposed injunction may cause to the opposing party. And the 11th ended up concluding that there wasn't a conflict because the statute they interpreted it to mean was only limited to what could be considered for purposes of determining enforceability. And that Rule 65 had to do with the remedy, sort of leaving open what would happen for the remedy. Like I said, it wasn't designated for publication. It's not considering binding precedent, but it can be cited as persuasive authority. And that has been actually cited by a district court in 2016, and they refused to enter a preliminary injunction under the Florida non-compete statute because they did consider the harm to the party against whom enforcement was sought in fashioning the remedy. And I bring that up because I wonder if in litigation down the road at the state court level, certainly at the federal court level in Florida, you can do that. I wonder if those arguments might be available at the state court system. Back in the state court system, within about 3 months after that 11th Circuit Court decision in TransUnion, the Florida Second District Court of Appeal held in the Florida Digestive case, you can find this one at 192 Southern 3rd 491, that the statute that prohibits the court from considering whether there would be hardship on the employee should be considered. As I've gone through and I've looked at these other decisions from the state, from other states and other federal courts, when they say they're not going to enforce the Florida non-compete, it's typically because it's the consideration of harm and trying to weigh the public policy of that state against the harm to the purchaser or the employee. That brings us to this Madeira Caretenders case, which is called the White case. And I think that's the latest case from the Supreme Court of Florida on the issue of legitimate business interest. And the case was really interesting because it came up in the context of all these other jurisdictions complaining and criticizing the Florida statute. And the issue in the case before the Florida Supreme Court was actually really narrow. It was whether a home health service referral may be a protected legitimate business interest. And the court was trying to look at saying it depends on the context and the proof adduced. Referrals is not explicitly set forth in the statute as a legitimate business interest. Remember, we talked about it's not exclusive, and so other things could be considered. Well, the court there held that the word referrals does not have to be explicitly set forth in the statute because it's non-exhaustive, and because it's non-exhaustive, that doesn't preclude the protection of referral sources. But what's interesting to me about this is not that it was narrow or not that the court used typical rules of construction to come up with a holding. What's interesting is the parts of the opinion that go beyond that holding. It's like they wanted to take this opportunity to give further guidance to litigants and attorneys drafting these agreements and attorneys enforcing the agreements and courts trying to figure out how to enforce the agreements, what the view of the Florida Supreme Court is. And my read of the case is that the Florida Supreme Court was making clear that it's the trial courts that are well positioned, which means in the best position to construe the phrase legitimate business interests, and that they need to determine the legitimacy of a particular business interest in a particular case based upon those particular facts, which means you look at the industry context, you look at the evidence adduced. Just take a look or listen to these nuggets from the court on the scope of business interests. And here's what it said. This is the courts talking about the scope of unprotected business interests being well established by the courts, even if the legislature did not define the exact boundaries of the non-compete statute position when it comes to legitimate business interests. Listen to some of these quotes. And I give these to you in the context of how, as parties or lawyers, can we use these little gems from the Florida Supreme Court, if at all, in our practice or in the agreements that we sign to get better protection. The Florida Supreme Court said in this White case, the statute, quote, does not protect covenants whose sole purpose is to prevent competition per se, because those contracts are void against public policy. The court said for an employer to be entitled to protection, quote, there must be special facts present over and above ordinary competition, such that absent a non-compete agreement, the employee would gain an unfair advantage in future competition with the employer. Another quote, additionally, the statute is set against the backdrop that contracts against the restraint of trade are generally unlawful. And the final quote, thus section 542.335 is a carve-out of the general prohibition, striking a delicate balance between legitimate business interest and a person's inalienable right to work. So, taking all that into account, I want to talk about new state legislation in Florida and other states. And before I go to Florida, I think I want to talk about the other states. And that is that other states, I think in courts and in legislatures, are coming to the realization, at least in those states, that either the legislatures have gone too far and the pendulum has swung too far over to the employer's side, and they're trying to even the playing field in one of two ways. Either the courts in other jurisdictions are not enforcing what the legislatures have prescribed as law, trying most of the time to find public policy reasons or unreasonableness in their efforts, or the legislatures are going back and rewriting their statutes to be more in favor of the employee. And I think that's an important shift that we need to take notice of. And I don't have the time to go into too much detail, but they sure seem to be experimenting with that. And it reminds me of a study that I saw, and this was done quite some time ago, but it was done in conjunction with an MBA and a JD program. They were trying to compare restrictive covenants and non-compete agreements that were enforced in Massachusetts versus that were enforced in California. And at the time, California and Massachusetts were like the high-tech corridors, right? And that may have changed now, and there's certainly other states in play, whether it's Washington or Texas or maybe even in Florida. But at that time, what they were trying to figure out was what difference did it make for the competitive world when you have enforcement and non-enforcement of restrictive covenants and non-compete. And my recollection of the study was that in Massachusetts, where they were enforced, there wasn't the same cross-pollination of ideas and intellectual property because they were protected, and the courts enforced them, and the statute was stronger. And in California, the statute seemed to be more pro-employee, which allowed the employees to go and use their ideas from one company with another, and you would think that that could be really harmful. But I thought that the conclusion of the study was it actually helped grow those industries and grow the ideas because there was collaboration rather than trying to keep everything in one employer or another employer versus another. Just a couple of things I wanted to point out from other jurisdictions to show how this works before I go back to Florida. This one happens to deal with Nevada. In 2016, the Nevada Supreme Court rejected that legislature's blue pencil rule. And remember when we were talking earlier about the discretion under the Florida statute for what they can do with restrictive covenants and non-compete provisions is they can rewrite them as long as it's properly drafted and it's following the statute and make them reasonable. Well, that was what the law was in Nevada too, and the court rejected that. So within a year, the Nevada legislature reacted and enacted a new statute which significantly changed the judicial principles. Now that statute's very involved and it's a little confusing to me, in that it's contrary in different things. And in some places it makes enforcement easier. In other parts of the statute, it makes protecting the former employees more easy. It's a confusing statute, but there again, like other legislatures and what the courts are trying to do, they're trying to balance reasonableness on both sides. So let me go back to Florida. And Florida went ahead and in 2019, I think it was actually the 2018 legislative session, passed a new statute dealing with physician non-competes, and that's section 542.336. That became effective June 25th, 2019. And essentially the new statute limits the use of a physician's non-compete agreements. The new statute voids any non-compete agreements between specialist physicians. That's the important part. They specialize in a particular healthcare service. And any entity that employs or contracts with all the physicians of that specialty in a given county. So the other important part of that new statute is that it provides that it remains unenforceable. The non-compete restrictive covenants remain unenforceable for 3 years after the date in which a second entity starts offering the same specialty services in the county. Now, this new law was not without controversy. Healthcare provider organizations like healthcare systems and hospitals have been using non-compete agreements to lock their physicians in and protect their investments in their network and facilities and patient base for years. Now, on the other hand, rural hospitals were complaining that the new law bars their ability to offer patients specialized medical treatment. So, less than 2 months after the law's effective date, a trial judge, federal district judge in Tallahassee, refused to enjoin enforcement of the new law. This judge started his ruling by comparing the plot of the plaintiff's case to being similar to the plot in the movie The Creature of the Black Lagoon, which was filmed about 15 miles from the Tallahassee courthouse in the 1950s. And things did not get much better for the plaintiff after that. The ruling is clearly a setback for healthcare organizations because essentially the court ruled at the current stage of that litigation, the motion for injunction should be denied because the public purpose of the statute, and there was actually a public purpose put forth in the statute, which was increasing competition by voiding certain non-compete agreements, could have a meaningful positive effect on healthcare, and that was a legitimate public purpose, and that outweighed the fact that the employer's contracts of employment with the doctors were being impaired. Let me just give you a little quick factual background about this because it was so interesting. Here's what I think happened in that case. There was a county in Southwest Florida. The employer had 9 of the doctors, the only 9 doctors that were involved in that specialty. 5 of the doctors broke away. It appears from the opinion they hired some very good lobbyists that were able to push this law through. The law became effective. They then left, and the employer tried to enforce it. They put up the statute that they had passed, and they won. So, what are ways that employers and employees can lose restricted covenant cases, and what are the key takeaways that you can come up with from this? Here's what I'll tell you. Employees and employers lose these cases based upon reasonableness, legitimate business interest, public health, safety, and welfare. Those 3 are the areas. If you have it, you're good. You don't, you're not. Just depends on which side you're on. Key takeaways, these are enforceable. They're enforceable if they're properly executed, if they're properly drafted, and if they're properly enforced. And at this stage, I'm going to turn it over to Teresa Phillips to talk about trade secrets. Thank you.
Hello, I'm Teresa Phillips. Glad to be here with you today. Following up on what Skip has just taught us today and explored, I'm going to be speaking on trade secrets. Now, when we talk about trade secrets, they similarly have a statutory scheme that is followed in most states, and there's a federal statute we'll also talk about. But we're not just talking about agreements and or law that governs your relationship with your employees. These laws and any contracts that you prepare related to these can also affect customers, vendors, and really any third party outside the organization of the client that may come in contact with what is deemed a trade secret. To start off with, we'll go over the applicable laws that you'll be looking at. We'll delve a little bit more into what constitutes a trade secret, what constitutes misappropriation of a trade secret. We'll look at some contractual duties that you can have related to trade secrets, and finally look at the remedies that may be available when there has been a misappropriation of a trade secret. The applicable law that we're looking at are two primary statutes. It's going to be your state statute and a federal statute. Most states, last time I checked, 48 states of the 50 had adopted state statutes based on the Uniform Trade Secrets Act. Florida has one. It's called the Florida Uniform Trade Secrets Act, and it's found in Chapter 688 of the Florida Statutes. The federal statutes referred to as the Federal Defend Trade Secrets Act, or Trade Services Act, and it was passed pretty recently in 2016, and it's found at 18 U.S.C. Section 1836. There's a lot of similarity as that both were modeled over the Uniform Trade Secrets Act, but basically the FUTCSA is a very only material difference of the FUTSA to the Uniform Trade Secrets Act is it requires that the alleged trade secret must be alleged with particularity and specificity. The Federal Defend Trade Services Act is the federal statute that applies in the same context, and it prohibits the misappropriation of trade secrets just like the FUTSA. In addition to these two statutes, you also have common law remedies in most states, but understand that the FUTSA has preempted any other common law tort claims that rely upon the exact same facts as a misappropriation of trade secret claim. And I think you'll find most of your state statutes have that as well. So to the extent it's a tort claim, and to the extent it relies on the same facts, you may just be limited to what the statute provides. So what constitutes a trade secret? By definition, a trade secret means information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic values from its disclosure or use. Also, it's the subject of efforts that are reasonable under the circumstances to maintain its secrecy. In common language, it's something that because you've prepared it, you've created it, you've discovered it, and other people do not know about it, it has some kind of value, especially because your competitors do not know about it. And that by definition, if it's going to be a trade secret, it has to be kept secret, and there has to be reasonable efforts taken to maintain that secrecy. What are some common examples and maybe not so common examples? Probably the go-to example everybody comes up with is the formula for Coca-Cola. Coca-Cola formula was not patented or back when it was discovered or made in the 1800s, I believe. But it's a trade secret. It's kept under lock and vault. It used to be made a big deal that it was kept at a bank in Atlanta. Now I believe it's kept at the Coca-Cola World Center there in Atlanta. But under lock and key and apparently very secure. What's some more examples? Software source code, not open source code that's generally available to the public, but other source code that's in software and products that where the general public doesn't have access to the source code. Manufacturing processing in the making of goods, the specific process. If you've come up with a specific process that's not necessarily known, that can be a trade secret. Customer lists in certain circumstances can be when those lists can't, or those customers can't be ascertained from a public record or other easily available source. Price list, if you don't make your prices or quotes public or readily available, those can be trade secrets if it gives your competitor some kind of advantage to know that, or puts you at a disadvantage if they know that. And then sales and contact databases. And I put a little note here under special circumstances. Now I've put that note because it depends on the circumstances. And I'll give you an example of two things I've come in direct contact with in my practice and have had to analyze. And both at the end of the day, the alleged trade secret was nothing more than the sales and contact databases of the companies. But first, I'll put it in the context of a realtor. Realtors have a list of their contacts, people they've listed, sold to, been involved with, and their listings, the properties, the amounts that were listed for, the amounts they sold, things of that sort. But generally speaking, it's hard to have such a list without anything more be deemed a trade secret, in my experience, because all that information can be ascertained from public databases, either the public records themselves that have that give you information on sales information, or the MLS listings on those. So it's hard to say with just that information that would be a trade secret. Now let's compare that to a list that maybe a broker has in an area that isn't subject to the public record search. Maybe a secondary market for goods or manufacturing equipment. If you're a broker that essentially does the same thing as a realtor, you just broker deals, but it's in a context of private deals that aren't made public record, people wouldn't readily be able to tell you what those machines were worth or what they sold for on a secondary market. You may be compiling information that's not readily available. You may be compiling information about what kind of machines people are hold, how long they've had them, what's the lifespan on them, that nobody would be able to just Google and find out and obtain without going through a lot of labor. And those lists and databases may be coming under now the protection of trade secrets. So when you look at these kind of things, you always have to go back to the analysis. Is there something here that I have that I've come up with that derives value because it's not known and it can't be known without significant effort? Let's think about trade secrets in the context of patents and copyright registrations and such. Trade secrets, obviously, by definition, they do have some intellectual property characteristics to them. So you may ask, well, why don't you patent your trade secret or copyright if that's more appropriate? And I think as the advisor or someone who's looking at this from a client's perspective and want to give them advice, you have to really delve into the facts and determine if trade secrets might be of better benefit. It may just be quick to presume patents and copyright protections would be more favorable because they're registered, they're formal, they're known to the world. But you have to remember there's some things about trade secrets that can be more favorable, especially if you want to keep it a secret that you have this. Or that FUTSA preempts tort claims. It does not preempt contractual claims and contractual remedies. In addition to damages, you can look at punitive damages under the Florida statute. That can be double your actual damages. And you also can get prevailing party attorney's fees in that action. That means if you prevail on either side. There can also be attorney's fees for the defending party if they prove bad faith on the part of the claimant. And any party who brings or defends a motion to terminate an injunction in bad faith can be assessed fees. So summarizing and circling back to what Skip was talking about earlier, we're looking at this law for trade secret protection. Trade secrets can be one of the most valuable assets of a company, and just like the other mechanisms that we looked at earlier, the courts here are trying to weigh the policies of not restraining trade, but also protecting innovation and protecting businesses and their legitimate business interests. Thank you for your time.